5 seconds to go. Start. Section 50 of the PMLA merely indicates the substantive power of ED to someone but does not provide the procedure for exercise of such power. The procedure relating to territoriality of investigation or power to summon sick or infirm women, children, and record their statements has not been provided under Section 50 of PMLA as it is provided under Section 160 and 161 CRPC. Power without guidance for manner in which it is to be exercised could not be said to be fair, just, and reasonable procedure established by law under Article 21 of the Constitution. A combined reading of Section 4(2) CRPC and Section 65 PMLA would show that the application of the Code is not barred as long as the provisions of the Code are consistent with the PMLA. The judgment of this court in Vijay Madan Lal Chaudhary and others versus Union of India and others has not dealt with the issue of procedure for summoning under Section 50 of the PMLA. The CRPC provides that the existence of the territorial nexus to the commission of a crime is a jurisdictional threshold for the exercise of powers of investigation by a police officer. However, the respondent ED has not demonstrated as to how it could be prejudiced by calling the appellant number 1 to its office in Kolkata, where the ED has the zonal office. The Department of Revenue, Ministry of Finance has issued administrative instructions consistent with Section 51 of PMLA that demarcate the specific territorial jurisdiction of various zonal offices of the ED. The said instructions must be strictly complied with by the ED in consonance with Article 21 of the Constitution of India. The appellant number 1 is a permanent resident of Kolkata and being Member of Parliament has a residence in Delhi, which however does not alter his permanent residence at Kolkata. Section 91 of CRPC only deals with summons for production of documents, whereas the summons issued to the appellant number 1 under PMLA are for personal appearance before the respondent at New Delhi is nothing but an abuse of process of law. In addition to the above submissions, Learned Senior Counsel Mr. Abhishek Manu Singhvi, along with Learned Senior Counsel Mr. Gopal Shankara Narayanan, appearing for the appellant number 2, broadly made following submissions. The appellant number 2 has been summoned to appear in New Delhi despite she being a homemaker and a mother of 2 children. The ED has created zonal offices and has an office at Kolkata. Therefore, summoning the appellant number 2 in Delhi is illegal and reeks malafide. The appellant number 2 is neither an accused in the predicate offence nor in the money laundering offence. Protection of women provided under Section 160 of CRPC would be applicable to the PMLA also. Section 65 of PMLA makes provisions of CRPC applicable insofar as they are not inconsistent with the provisions of PMLA with regard to arrest, search and seizure, attachment, confiscation, investigation, prosecution, and all other proceedings under the said Act. Therefore, in the absence of any specific procedure for summoning of witnesses, the CRPC will apply. Article 21 of the Constitution provides that a person's life and liberty can be curtailed by state only in accordance with the procedure established by law, and therefore the procedure for summons curtailing the right of the appellant number 2 to life and liberty must be just and reasonable. Stop.